versus Axis Supply Corporation. Mr. Ruiz.
Good morning, Your Honors. May it please the Court. My name is James Ruiz, and I'm here with my co-counsel, Ellen Eisenhower, and we represent the appellant, Axis Supply Corporation, in a case where the district court found it infringed on the trademarks of the appellee, and specifically two trademarks: Appliance Liquidation Outlet, a word mark, and Appliance Liquidation, another word mark. The case, however, focused for the most part on a third trademark, which I gave the court some demonstratives, which was the Appliance Liquidation Outlet logo mark, the composite mark. And the evidence at the trial established that this was the mark that the appellee created in 2008. It was their brand. And this was the mark that everyone identified them with. Now, during the trial, during the case, in that trial, the appellee conceded that Axis Supply did not infringe on this mark. So while a lot of focus was on this mark, this was not the basis of the infringement claim. They said we didn't.
Is the logo at issue on appeal, or is it just the trademark of the names?
I'm sorry?
Is the logo at issue on appeal?
No, but it was the focus of the trial. All of the evidence where they tried to show secondary meaning went to the logo mark. In fact, Mrs. Frere testified, and she was the head of marketing, that this was the mark that was on their business cards, their T-shirts, their caps. I mean, it was on everything. It was on the trailer, and it was the mark that, as Mr. Frere testified, it's what they were known for, this mark. And the important thing about this mark, too, is the mark is Appliance Liquidation Outlet, San Antonio, Texas.
Yeah, but one thing you didn't do is put in what their wall looks like, where it says Appliance Liquidation Outlet on the side.
Yes.
Which is something you left out of this thing you handed us.
Yes, Your Honor.
On purpose.
No, Your Honor, no, it's not on purpose at all.
Because that's much more similar to you all's.
And, Your Honor, and you're talking about the signage. And the signage, Appliance Liquidation Outlet.
On the wall.
It's on top of the warehouse. It is 96 feet long and 4 feet tall. And that is the only place where they could show they ever used the word Appliance Liquidation Outlet on that sign. And they did say you can see that sign from a long way away because it's 96 feet long. Now, if that is a mark, then they would have to have that long sign or something similar on packaging or materials, because as the U.S. Supreme Court stated in the recent Jack Daniels case, a trademark is not a trademark unless you use it to distinguish the origin of your products from that of others. And that means you have to use that mark to show this is my product, this is the source or the origin of my product or services.
Can I ask you, on you all's, so you put your wall, your outdoor wall, I don't see where it says Axis.
That's correct, Your Honor.
Okay, so the only thing, if I was coming to your store, that I would see is this Appliance Liquidation and then this little different sign that says sale.
Correct.
Right? Okay.
And as Mr. Frere, the appellee's owner, testified, yes, reasonable people would see that that is just a wraparound banner sign promoting an appliance liquidation sale. He testified that on the record. But then he went further and said, but uneducated people may be confused.
Yeah, but what I'm trying to understand is, how am I supposed to know what the name of this store is? If I walk up to this store to buy something, what am I going to think the name of the store is?
When you walk in, the evidence with the receipts had Axis Supply Corporation on it.
The receipt?
Yes.
Okay.
But
That's it?
Yes.
And nowhere in there, if I'm wandering around looking for stuff to buy, is
Right.
there any sign that says Axis or whatever?
No, Your
I
Honor.
have to read my receipt, which
Yeah.
everybody reads a receipt at great length, right?
And that's a valid point, Your Honor, because one of the issues that made this case somewhat unique is the distribution channel by which Access Supply Corporation sells their products. This was not a store, this is a storage shed. This is a place where you picked up the products you purchased from OfferUp and Facebook Marketplace. As the evidence at trial showed, and as the court found.
You can't go in here, is what you're saying.
Yeah, it's just a big warehouse. It's just storage.
In the warehouse to see what you might be interested in?
No, there was no evidence at all that anyone goes and shops inside this store. In fact, on the call log, which we'll get to in a moment, the people's complaint was, it's dark there, I'm coming to pick up the refrigerator I got on OfferUp, etc. I mean, that was some of the logs that they had on the call log. So no, the evidence was that they exclusively sell on OfferUp and on Facebook Marketplace.
I knew that was their main sale. I didn't realize that you could never go in.
Correct, yeah. I mean, and now, when we get to the second, they did move to a new location, which has more of a store setting, but they have appliance surplus there, you know, just to make sure there's no confusion. But to get to the issue, Your Honor, again, appliance liquidation sale, the wraparound banner sign is not a mark because Access Supply Corporation, aside from having it posted on the side of their building, never used it on any post. There's no evidence at all that they ever had this appliance liquidation on any of the OfferUp posts or any of the Facebook Market posts. The evidence was they do no advertising, they have no website, no internet. It's just, and I guess the OfferUp is like Craigslist, or when I was growing up, the old green sheets, where it's basically anonymous. There's offers, you can buy this for this amount, and it has just a code or something, or press this button to contact the seller. And the evidence showed that where people were getting confused is because, again, there's no phone numbers, there's no addresses for most of the posts. And they brought the one consumer they brought as a witness, testified, and he has actually been someone who he's testified had been shopping at Apple's appliance liquidation outlet for 10 years. He said he saw a post on OfferUp. It had no address, no phone number, and he was interested in the product, so he Googled appliance liquidation stores. And the first one that pops up is the Applee, because they pay to be the top search result if you type in appliances in the San Antonio area. And if you look at the call log, which the court admitted for the limited purpose of showing confusion, all the calls, for the most part, the overwhelming majority are people saying, I'm looking for a phone number about a post on OfferUp or on Facebook Marketplace. They're looking for phone numbers because they want more information about the product that's being posted. While the whole purpose of the website that they sell these things is you're just buying it. I mean, it's anonymous. You can click a button. If you want to ask an inquiry, you can make it. But there's not a phone number, call me, I'm going to give you more information about this product. Just like a Craigslist. I mean, it's not a situation where you're going to contact someone and they're going to haggle with you about a product. So that's the thing that made this case a little different, and but that gets to the point of why there's no trademark infringement. Because in this case, they never identified what were the two marks that, in the evidence, that allegedly were infringed upon, and what was the alleged infringing mark. Because if the alleged infringing mark was just a wraparound banner sign promoting an appliance liquidation sale, then every time you'll see any ad in the paper saying appliance liquidation sale, now we're saying they're infringing on any common law rights that the appellee has to appliance liquidation.
So is the nature of your argument that appliance liquidation is generic?
Yes, it's very much generic. In fact, Mr. Ferrer testified that there are companies, stores all over the country called Appliance Liquidation Outlet, but he's the only one in San Antonio. So he admitted that Appliance Liquidation Outlet and appliance liquidation are used generically in the appliance discount retail industry, but he was the only one in San Antonio, so he thought that gave him rights to be the exclusive person to say appliance liquidation in San Antonio. In fact, the district court found in the findings that the words appliance, liquidation, and outlet are all generic terms.
Well, can you explain why they didn't change it? I mean, you're saying it's not a store people can shop in. Why didn't they simply change it?
And Your Honor,
They were asked to.
yes, and the reason why they didn't change it when they were asked to is because they were being told that you need to change the name of your store because you're infringing on our mark. And this was their mark. And we're not infringing on this mark.
A mark can be more than just a logo. It can be the name as well.
Yes, it can. But in this instance, when the case was filed, they filed for several claims. They filed for federal unfair competition, state unfair competition, common law trademark. They also filed for unfair and unjust enrichment. And so to get to Judge Haynes, your question, when the suit was filed, you can't stop us from advertising appliance liquidation sales, and we're not infringing on your mark. And we filed a motion for summary judgment. And the court ruled on that on December of 22, granting the summary judgment in favor of Access Supply with the sole exception of the common law infringement claim. So we won every claim but the common law infringement claim on summary judgment, which the court said he'll hold over to trial. So why do we not change the name?
You mentioned earlier, I'm sorry, maybe you haven't finished answering
No, I'm sorry.
this question. Have you completed your
Yeah, well, so after the summary judgment was entered in December of 22, the trial is 3 months later, and at that point in time, there was a change of store locations. And what we told the court at the pretrial hearing is, we left the banner behind. There's no banner at the new location. So changing the name, the name of the store is still Access Supply Corporation. It's just it no longer has a banner that's promoting an appliance liquidation sale at the new location. And that's the timing of that, Your Honor. We're still Access Supply Corporation. We've always been Access Supply Corporation. And in fact, when we were sued as Access Supply Corporation, not DBA Appliance Liquidation or Appliance Liquidation Sale, because that's not the name of our store. And so the change of the name went with the moving location and leaving the banner behind.
Sorry, that makes no sense about not changing it, since you say it doesn't matter, it's not really a store.
Well,
People just picking up, and so I mean.
but, Your Honor, it matters in,
Determinative of the case, but it doesn't make a lot of sense.
but Your Honor, it matters in this regard. The issue's not moot. It's still not moot because under the appellee's argument, they have the right to stop anyone from promoting an appliance liquidation sale. And that's wrong. I mean, think about how that impacts just the industry. You can't say, if your name is, you can't say your appliance outlet because they're going to say it's confusing. I mean, you can't, appliance liquidation sale, that happens all the time, and they're saying, well, no, that's infringing on our mark. A mark, by the way, which it's not even in the record. There's nowhere in the record that shows appliance liquidation outlet or appliance liquidation merely being used to designate the origin of their goods and services. It's nowhere. All they have is their composite mark, the logo mark, which they admit we didn't infringe upon. And so the issue with, why didn't we change the name? We didn't change the name. We just moved locations and didn't take the sign with us. And then secondly, the issue still wasn't moot because we still would likely have the right to, if we desire to have an appliance liquidation sale, to promote one. And under the court's order, you can't.
You mentioned earlier that the words appliance, liquidation, and outlet individually were generic. But couldn't there be secondary meaning as to the combination of the words?
There could be secondary meaning. And that's where the judge, again, made error because he lowered the standard of secondary meaning. This court said it's a high degree, a high standard that you have to meet. The court standard for secondary meaning, he relied upon the call log to show the confusion was what the secondary meaning showed and some Yelp reviews. And that's not the standard because the one thing about the call log is the call log was, the evidence at trial was made for the sole purpose of litigation. So as one court held, it's a tool of controversy, not a business record. So the call log, number one, it doesn't say anywhere that the appliance liquidation mark, that they thought they were going to that store or they associated any of the posts with appliance liquidation outlet. They said, I'm looking for a phone number. Secondly, to get secondary meaning, you have to show that you put in a lot of money advertising and promoting it. In the record, there's no evidence they spent any advertising. None. None of it's in the record. All they have is the trailers, and they're merchandise for the stores, which has their composite logo. So there was no evidence in the record that they spent a lot to create secondary meaning. And secondary meaning means that the name is uniquely associated with the source of the goods. So when people think appliance liquidation, they think of this store. Appliance liquidation outlet, they think of this store. And I'll have my rebuttal time. I know I've ran out of time.
Yes, you've saved time for rebuttal.
Yes.
Mr. Ruiz.
Thank you, Judge.
Mr. Guinn.
Judge Smith, Judge Haynes, Judge Douglas, may it please the court. My name is Nick Guinn, and I represent the Plaintiff Appellee Appliance Liquidation Outlet, LLC. I'm joined by my co-counsel, Matthew Batters, along with Carlos and Kimberly Frere, the owners of Appliance Liquidation Outlet, LLC. We respectfully request this court affirm the decision of the lower court on all issues presented. In particular, the court had all evidence establishing that the mark was not generic, but instead descriptive, and that it had acquired secondary meaning. Second, the court properly found that the marks as used by the two parties exhibited a likelihood of confusion. And third, the court properly held that this case is exceptional. One thing that Axis has failed to acknowledge is the standard of review with which this court reviews the evidence and the tests that are applied by the lower court in reaching its conclusions. Before I address some of the points that I prepared for today, there's a few issues I'd like to address raised by the Axis during its opening argument. The first of which is that there's this trichotomy or these three discrete marks that are to be considered: appliance liquidation outlet, and my client's logo. The issue of whether or not my client has referred to itself as appliance liquidation really is irrelevant in this case because the court properly held that my client has established trademark rights in the name appliance liquidation outlet. Axis confuses the issues by trying to dissect the logo from the name appliance liquidation outlet, but as the demonstrative exhibits reflect, and as all evidence at the trial court demonstrated, my client consistently and continuously for the last 25 years has used the name appliance liquidation outlet. In fact,
They use just appliance liquidation?
they have not used the name appliance liquidation, although when returning phone calls or answering phone calls, it sometimes would use the name appliance liquidation, but it changed that after Axis showed up in town, so to speak, to prevent confusion, so it began referring to itself by its full name on the phone, appliance liquidation outlet. But the distinction between appliance liquidation outlet and appliance liquidation, as far as my client's use is concerned, is immaterial to this court's analysis because the question is, does my client own a valid trademark? And yes, it does. And is there a likelihood of confusion by the defendant's use of its mark that it has adopted, appliance liquidation?
Now, do you think it matters that they left out y'all's sidewall in this thing they handed us?
I think those materials are really, frankly, irrelevant and not very helpful today. But I think it is.
Because this, to me, looks a lot more like this.
I would agree with that. One of the factors in
But
the
they left it out
we did. One of the factors in the yes.
of this thing they gave us.
One of the factors in the likelihood of confusion analysis, similarity of the warehouses. Now, today is the first time I've heard that people were not welcomed into the 2602 Fredericksburg location. That was not evidence at the trial court. It's not a part of the record.
Okay,
In part because the defendant did not call any witnesses or introduce any exhibits of its own. But someone who's driving down Fredericksburg Road who is familiar with my client's business or maybe not, but they've heard of it, they see a warehouse-like building with a white sign with red letters, big red letters that say appliance liquidation. It's not surprising that people would confuse them, which led to more than 300 recorded instances of confusion on my client's confusion log, as well as instances of confusion reflected in Google reviews and other online review sites.
So one term that I haven't heard either of you used yet today is the term source identifier. Tell us what is the significance legally of the term source identifier and how it fits into the facts here.
It's extremely important, Your Honor. A source identifier is a trademark because the purposes of trademarks are to provide the source of goods and services, because at its core, in a pretty significant distinction from trademark law and other areas of intellectual property is we want to protect consumers. We want to protect consumers from confusion, the type of confusion that we see here in this case. And so my client over the last 25 years, through directly and through its predecessor in interest, has established strong trademark rights in the name Appliance Liquidation Outlet, reflected in the secondary meaning that has developed. And one of the issues that Axis argues that there was no evidence of secondary meaning, and frankly, that comes as quite a surprise because plaintiff introduced evidence in support of each of the 7 factors, the Pebble Beach factors, if you will, supporting secondary meaning. What I think is most telling is the 5th factor, which is consumer survey. Now, frankly, I think the court, in adopting the Pebble Beach factors and articulating that 5th factor as the consumer survey factor, kind of lets the tail wag the dog. Consumer surveys, which are somewhat commonplace in Lanham Act cases, are intended to fill gaps or try to provide an explanation or identify what is the consuming public believing or thinking, whether that's an issue of confusion, that's an issue of secondary meaning, genericness. There's a variety of surveys that can be performed. And the reason why we consider consumer surveys as the 5th factor on the secondary meaning analysis is to assess, do consumers believe that this mark is recognizable by the relevant consuming public, i.e., is it a source identifier? And so in this case, we have 300 recorded instances of confusion, among others, which is strong evidence that the consuming public recognizes the source because they are confused as to the source. And so if consumers are confused as to the source, they implicitly recognize that name as a source identifier. This court, along with almost half of the other circuits, have uniformly held that strong evidence of customer confusion is strong evidence of secondary meaning. This court, in the Viacom decision, which Your Honor, Judge Smith, was on the panel on, addressed the Krusty Krab SpongeBob SquarePants case and whether or not the Krusty Krab had acquired secondary meaning. In that case, Viacom did not perform any secondary meaning surveys. It performed customer confusion surveys, and the court said that was strong evidence that the mark had acquired secondary meaning because customers are confusing these marks. And so here, there was no need for a survey. We had strong evidence of customer confusion because the customers recognized my client's mark as a source. In addition to the strong evidence of confusion, my client also elicited customer testimony. We have customer testimony, live testimony by way of Bradley Flume, the longtime customer that Mr. Ruiz referenced, who testified his familiarity with the business. We had the testimony of my client's owners and employees who offered anecdotal explanations or stories of their encounters with other people in the community. Someone would ask, say, the San Antonio fire chief, "Oh, where do you work?" "I work at Appliance Liquidation Outlet." And the people didn't respond, "Oh, which one?" or "What type of business is that?" They'd say, "Oh, that's precisely where we buy our appliances." And in the case of the fire department, that's where we buy our appliances for the San Antonio Fire Department. We also had 250 Google reviews, many of which would say, "I love shopping at Appliance Liquidation Outlet, capital A, capital L, capital O. I love working with Lauren Kuhn. I love working with Carlos or Kimberly." They clearly recognize my client's business. They recognize the name, and they see it as a source identifier for my client's business. And so this is extremely strong and compelling evidence of secondary meaning. We also elicited evidence in support of the first 4 factors, length and manner of use. In this case, my client, at the time of trial, had used the mark for 24 years. The sales data, which Judge Rodriguez acknowledged was a strong and significant number for a local business. The third factor, amount of advertising. My client testified as to efforts in the community, charitable contributions, sponsorships at UTSA, University of Texas, San Antonio Missions Baseball, and other events where people around the community could see my client's name. Events that my client would host, art shows, car shows, and other activities that were...
All of this was related to Appliance Liquidation Outlet?
Yes, Your Honor.
Do I understand your argument to be that if they have secondary meaning as to Appliance Liquidation Outlet, they also have meaning as to Appliance Liquidation?
I'm not sure how to answer that question, Your Honor, other than I don't think that's the appropriate analysis, because my client's mark is Appliance Liquidation Outlet, and if you look to the words of the Lanham Act as well as the jurisprudence on this subject, the issue is, does the plaintiff or does the mark owner own a valid trademark? And by establishing secondary meaning, yes. Then the second question is, does the defendant or does another party use a word, a term, a device, a symbol, there's a long list of things that could be done, that is likely to cause confusion, mistake, deception as to the source, sponsorship, affiliation of the mark owner. And in this case, because my client owns a valid trademark, Appliance Liquidation Outlet, and the evidence shows that the defendant, Axis, has adopted a name, Appliance Liquidation, that causes confusion as to the source, then trademark infringement, or in particular unfair competition, is established.
How else would they describe their business? If they are in the business of selling or liquidated appliances, then how else would they describe it except to say that they are an appliance liquidation, whatever?
I believe the appropriate term that most people would use would be an appliance retail store, an appliance store, a discount appliance store, a scratch and dent store. There's a variety of terms that can and are used by customers, not appliance liquidation outlet. And that it.
Common nationally to use the terminology appliance liquidation?
Appliance liquidation. I'm not aware of that being commonly used. In fact, there was no evidence on the record to suggest that it was. And this goes to the question of genericness. And the Supreme Court's decision in USPTO versus Booking.com from about 5 years ago is instructive here. That court reminded us that the analysis for genericness is, do customers perceive the term as identifying the class of services, i.e., is it generic, or is it used to distinguish sources? And in all evidence elicited at trial from the 4 witnesses that my client called, the exhibits that were introduced, all evidence established that no one uses the term appliance liquidation outlet in a generic context or to identify the class of services. In the Booking.com case, the court posed the question, do online travel agencies refer to their services as Booking.com services? Does Expedia say they provide Booking.com services? Does Travelocity say that they provide Booking.com services? And the answer is a resounding no. And so similarly, there was no evidence presented at trial that customers or merchants refer to this class of services as appliance liquidation outlet services. All evidence was that it's used to identify my client's business. Now, the Axis raises the issue in its brief and today that there was evidence of third parties. And I don't dispute that there are third parties in other geographic markets that use the name appliance liquidation outlet, but that one isn't particularly relevant to my client's rights and trademark, where the injunction was granted and the findings of fact were, the analysis was carried out. Axis actually acknowledges that those third parties identify themselves as, or they name themselves, appliance liquidation.
You're claiming it for the San Antonio area, not for the United States.
That is correct. And so there is no evidence that other businesses in San Antonio refer to themselves as appliance liquidation.
Okay, let me ask a hypo. What if we decided to affirm? Why then would we also affirm the attorney's fees?
Your Honor, the question of attorney's fees, as this court is familiar, the analysis changed with Octane Fitness and subsequently in this court's decision in Baker v. DeShong in 2015. The Supreme Court had analyzed, was tasked with deciding, does the former bad faith fraud analysis apply to exceptionality? And for a lengthy discussion, because I know it doesn't, it would have been superfluous in light of Rule 11 procedures and mechanisms for granting sanctions. The court said it's a lower standard now, and it can be established when the trial court finds that this case stands out from the others as exceptional in one of two situations. Either the parties' litigation positions or the relative merits of the case are so disparate, or the case stands out because of the conduct of one of the parties or the not prevailing party in the case. In this particular case, the trial court held that the case was exceptional because the court expressly held that it was exceptional because the defendant was politely asked. In fact, Mr. Frere went to the plaintiff's or to the defendant's business in person, congratulated them on opening, but asked them to take down the vinyl signs and to stop referring to themselves as appliance liquidation. When the other side told him, go jump in a lake, he retained counsel, and several attempts were made before, early, and often throughout the proceeding to try to find resolution to this proceeding. And it was not until a week before trial that the defendant said that it has changed its name and it relocated and started calling itself Access.
Isn't that the equivalent of a cease and desist? And that happens all the time. What makes that exceptional?
So I think what makes it exceptional is the repeated attempts and the very reasonable and generous offers of resolution.
Or if I keep asking you and you never take it down until a week before trial, that makes it exceptional?
I think especially waiting until a week before trial and then not calling any witnesses to testify or introducing, offering any exhibits into to trial. The defendant made the plaintiff go through this exercise of taking this case all the way to trial only to change its name at the last minute. And coupled with that, the defendant was subject to a temporary restraining order at the beginning of this case, which it did not comply with. And had it complied, it would have been forced to take down those vinyl signs, which are apparent from those demonstratives with which the court has been provided, that probably cost $500 a piece to make and to repair, and to stop referring to itself as appliance liquidation. It didn't, and had it complied with the temporary restraining order, as it says that it doesn't consider appliance liquidation its name, it probably would not have resumed using that name, and this litigation would not have been necessary. And instead, the plaintiff was required to go through the process of taking this case to trial and prevailing on each of the issues presented. With respect to defendant's argument or Access's argument today that it doesn't use the name appliance liquidation, that comes as quite a surprise. Plaintiff's exhibits 37 and 39, which are on the record, and I don't have the ROA sites or the Record on Appeal sites, but they were the plaintiff's exhibits 37 and 39. They are records from the Bexar County Appraisal District that reflect that the defendant refers to itself as appliance liquidation, and a Facebook page that the defendant uses that refers to itself as appliance liquidation. And although not on the record before the court today, the defendant continues to post offers on Facebook Marketplace that say store, appliance liquidation. The testimony at trial also reflected that the defendant's receipts, which came up earlier in the questioning, say appliance liquidation. In fact, I think that is the top line text item on a receipt that a customer sees. Customers, especially in consumer-facing businesses, are accustomed to seeing names and.
I don't really know how Facebook Marketplace works, so explain to me, if it says store, appliance liquidation, is that because they are claiming that to be the name of the store or the type of store it is?
The name of the store, because underneath that it says address. And so a customer looking at one of those posts would think that's the name of this business, just like a customer driving down Fredericksburg Road would see the name appliance liquidation in bold, prominent letters to be the name of the defendant's business. Sale, I think, is superfluous, and I don't really know where that fits into the mix other than that's.
Well, it's not really part of the sign. It's not the same letters. That's why, to me, that isn't they're not making it the name appliance liquidation sale. They're making it appliance liquidation, and then sale is a separate word. That's what it seems like to me.
I agree, and I think that's how a customer would perceive it. Yeah, as someone who practices trademark law almost exclusively, we're trained to assess what is a trademark, what will satisfy.
Particularly this one, where this little sale is off to the side. I wouldn't think that's part of the name of the store.
Right, and I recall the Foley's Red Apple sales, and it seemed that those sales were quite frequent. But the reality is that businesses are not perpetually in a sale, as Access argues, and that's the sign that was on the store. Some are, but I don't think a customer would perceive a sign like that, especially if it's up all the time, as indicating that appliance liquidation isn't that business's name. One point regarding the exceptionality that I would be remiss if I didn't address is the fact that this court, since Baker v. DeShong, has consistently reflected a strong deference to the trial court and given great discretion to the trial court on the question of exceptionality. In fact, I believe it was the Vetter v. McAtee decision from 2017 that says this court vests significant discretion in the district courts to grant or deny attorneys' fees, and that was a Lanham Act decision. In this court's 6 Lanham Act exceptionality cases addressing exceptionality, since Baker v. DeShong, this court has consistently reflected given a strong discretion to the to the lower court. And one point that the Axis raises in its brief is that damages were not awarded. It references the CJC Holdings case from 1992, which certainly predates Baker v. DeShong, so the old standard. But even that case said that damages were a factor to be considered. Since Baker v. DeShong, this court has not once indicated that damages are a factor to be considered, much less adopted a per se rule that damages are necessary when finding exceptionality. In fact, this court in Alliance 2, I believe there's 3 Alliance decisions, in Alliance 2, which Judge Smith was on the panel of, affirmed a finding of attorney's fees on the question of exceptionality when an injunction had been awarded but no damages. And so it's certainly within this court's precedent to affirm the decision of this lower court for awarding or finding exceptionality. I see my time has concluded.
Yes, thank you, Mr. Guinn. Mr. Ruiz for rebuttal.
Thank you, Your Honor. And Judge, going to exceptionality first, the Fifth Circuit in the Spectrum Association versus Lifetime Management case, which was post-Baker, it was 2021, held that the standard is still clear and convincing evidence to the degree of bad faith to find a case is exceptional for the award of attorney's fees. And the standard specifically that this circuit has...
Under the rule of orderliness, if we have a contradiction between 2 cases, we have to go with the older one unless in between a Supreme Court case came out or an en banc or a change in a statute.
Yes, I do appreciate that, Your Honor. And the standard didn't change, though. That's the standard Baker even uses. They say that the standard is you have to, in considering both governing law and the facts of the case stands out from others with respect to the substantive strength of a party's litigation position, or the unsuccessful party has litigated in an unreasonable manner. That's the standard this Fifth Circuit has had for decades.
Well, and you don't think this is kind of odd, sitting around refusing to do what you're asked to do, not you, but your client, until, a week before trial, we'll run and change it, ha, ha, ha.
Your Honor, that's not the way it worked. The way it worked is when they moved locations, and counsel knew that because we told them when we moved locations that, and he was talking about settlement discussions, we said we moved locations, we're leaving the banner sign. That was done in February. So after the summary judgment, the stores moved, and the testimony at the trial was that, yeah, they moved locations in January, February of 2023. So that's when they no longer had the banner sign.
You're saying it was just irrelevant, it wasn't related to the trial?
Yes.
Is that a factual issue for the judge to decide, the trial judge to decide?
No, Your Honor, and the reason why is because I think the standard is litigated the case in an unreasonable manner. And in the Rainier case that we cite, the court in the Northern District of Texas went through all the cases post-Baker to say when did the courts find cases were exceptional for award of attorney's fees. In each instance, it was due to something that would be violative of the rules on litigating a case, asserting a false claim, pushing a patent case when you know it was invalid, not doing pre-suit investigations and filing a suit that was meritless, pursuing a meritless defense, discovery abuse, misrepresentations to the court, misrepresentations of witnesses and testimony. That's what they said is litigating in an unreasonable manner. The store operating outside the courtroom is not litigating in an unreasonable manner. And that's the distinction. In the Lifetime case, this court found, when Judge Albright found that it was not exceptional, this court said, yes, it was, because the party engaged in discovery abuse, refused to supplement. Their witnesses did not testify accurately. And in fact, if you look at the record, that's what the court found the appellee did. The appellee, they have no damages because they refused to answer proper discovery. They didn't supplement. And then certain exhibits weren't allowed in evidence because while we exchanged exhibits prior to trial, they added pages to the exhibit they submitted to the court without telling the opposing party or the court. And the court said, no, you can't do that, and disallowed it. And then their witness testified, and this gets to your point, Judge Haynes, their witness testified that they had filed an application for the word mark Appliance Liquidation Outlet at trial, and it was still pending. It turns out that they filed that application after the trial using the judgment as a basis for trying to get a trademark on Appliance Liquidation Outlet. And in that instance, you have to give a specimen of how you've ever used that word to market it. They didn't use the sign because the sign's not a mark. Instead, for the Patent and Trademark Office, what they submitted was the copy on their website just saying appliance liquidation offers appliances. And they use the little highlight, appliance liquidation. But on that,
Application to the trademark office, limited in scope to San Antonio?
no. No. I mean, and that's the point. That's why this is such a bad precedent. Because basically, the court wanted to limit it to San Antonio on the injunction, which I think the injunction was moot, because even the court said, oh, it's not going to, on balancing equity, it's not going to harm access because they don't even use appliance liquidation anymore, which means that there was no reason to even issue an injunction. But he limited it to Bexar County, San Antonio area. In their application for the trademark office, they want appliance liquidation outlet nationwide. And they're using the district court's judgment as the basis to show, look, a court found secondary meaning, when the court may have found that, but there's no evidence to support it, because there's no evidence of anyone saying, yes, when I see that mark, I think of the appliance store. In fact, the example that counsel gave up here, when Ms. Kuhn's friend showed up, he said, oh yeah, I know that store. It has the mural that I worked on. No one says I know that store that sells appliances. They know the car shows and the art shows, and they created secondary meaning in that regard. And so the reason why the sign isn't in the...
Your time has expired.
I'm sorry, Your Honor.
Mr. Ruiz, and your case is under submission.